Welcome to Illinois Law. My name is Marty Dolan, and I'm your moderator for today's program. The topic today is environmental issues in real estate. Our guest today is Gene Schmidtkins, a member of the Business Services Practice Group at Evans & Dixon in St. Louis. He represents clients in environmental law issues, including compliance enforcement, including administrative litigation, insurance, permitting, transportation requirements, and transactional issues arising out of the sale of real estate and business. He's a frequent lecturer and author on a wide variety of environmental issues. Welcome to the program, Gene.
Thanks for having me.
Gene, you being an expert in this area, let me start off with the question, can a business owner be held responsible for environmental issues that existed on a property before the business owner purchased it?
Absolutely. The Superfund law, which is the most common basis for liability, specifically holds 4 different classes of people liable. And the first class of liable parties are the owner of the property or the operator of the property at the time of a release and the current owner of the property. So if you buy property, you have the potential to be liable for taking care of whatever problems took place long before you owned it.
Is there any length of time, a duration of time that it goes back where responsible, or is it?
Absolutely not.
Infinite?
This is, the Superfund law, we all learned in law school, for every wrong there shall be a remedy.
Right.
And you throw that out the window with Superfund law because it matters not at all when this occurred, how long, and it also doesn't matter if what you were doing at the time was legal.
What would be the practical advice you would give to somebody who's purchasing the property who may have that issue? What's the main thing they have to do?
Well, the law changed a little bit in 2002, and Congress created a brand new defense to liability called the bona fide prospective purchaser defense. And that defense allows you to purchase property that you know is contaminated. Up until 2002, you couldn't know that you had contaminated property, but now you can buy property that you know is contaminated, provided you do a few things. And you've got to have strict compliance with all of these. Part of the issue is you have to do certain things before you buy the property, and then you have what we call continuing obligations after you purchase the property. But the first thing you have to do to even be able to raise that defense is you have to do all appropriate inquiry. And the way that's accomplished generally in commercial transactions is that you contract with an environmental consulting firm to do what's known as a Phase 1 report, which is an initial look at the property, and they have to follow the standards set forth in the ASTM 1527.
And then from there, there's probably a myriad of things that could arise if there's something that looks wrong or whatever might happen.
Precisely. It's the purpose of a Phase 1 report. It's not necessary to determine whether there's any contamination. It's only to determine whether or not there's a potential for contamination. So there's no invasive sampling at all that takes place. All they do is go out, they look at records and historical uses of the property. They have to do a site visit to determine whether or not there's any staining or if there's any distressed flora and fauna. They have to talk to prior owners and operators, people that worked who might know whether or not there are any releases. And they have to review public records.
What about neighboring property that, there might be a problem next door that may affect yours? What's the situation with that?
Well, generally speaking, at the same time that this new bona fide prospective purchaser defense was passed, Congress also codified what had always been EPA's policy with respect to contamination that migrates onto your property. That's the contiguous property owner defense.
Okay.
That's been codified now. So if the contamination emanates now there are certain exceptions, and I teach a class on this, and I lecture for about 28 hours, so I'm trying to condense it a little bit. But generally speaking, if you don't own or you're not affiliated with the neighbor, and the contamination starts on the source is on their property, and it emanates to your property or migrates to your property, you have a defense to that.
If the property that you're purchasing is financed by a bank, would you recommend that you solely rely upon the bank's inspectors, or do you do something else?
That's the age-old question. It's interesting. I do have banking clients, and I do have a lot of know a lot of people in the banking industry, and when I talk about this defense, they didn't even know that it really had been passed. So there's a lot of people who still don't know about the defense, but you have to. I would always recommend. Now the bank may force you to do a phase one.
Okay.
And in all likelihood, they probably will. But the issue has never been with the bank whether they have any liability. The issue is all, in my opinion, it's all been an issue of collateral and whether or not there's sufficient collateral to support and to secure the loan.
Okay.
But yeah, you definitely want to hire your own professional and have that report done.
And lastly, let's just say there is a problem found. Who is forced to do the cleanup? Who's the person responsible for the work?
That's always, that's kind of, even though you have this defense, there are a couple of options. One, you can sue the prior owners to get a cleanup. There's also a number of programs in the states, and Illinois has one, the site remediation program, where you can go in and clean up based upon what the use is going to be. That's another change that's really taken place in our in environmental law. It used to be that you had to clean up your property to any use standards. In other words, what we call the eat the dirt standard. If you have little kids out playing and their hands get dirty, they can put their hands in the mouth,
right, and
you can live there. That's not the case anymore. Now you have some risk-based cleanup standards that you can go to depending on what the use of the property is. So a lot depends, and many people buying these kind of properties have the idea they're going to redevelop it anyway. So they anticipate they're going to have to pay some of their own remediation costs anyhow. Now the issue comes down to when you find something you really didn't know, like mega ethyl death, and you were only expecting, petroleum contamination, and you have something really toxic there, and it becomes exorbitantly expensive to clean up. Then you'll start looking at how you might get some satisfaction against some of the prior owners.
Gene, thank you for your expertise today on this topic. Again, this is Illinois Law, and thank you for joining us today.